The Constitution of the Republic of Trinidad and Tobago recognizes that freedom and democracy are inextricably intertwined, and that men and institutions remain free only when freedom is founded on respect for moral and spiritual values and the rule of law. Principles of equality and non-discrimination are fundamental components of the rule of law. They are akin to the jewels of a democratic state. Laws governing equality and non-discrimination reinforce the exercise of human rights and freedoms that are enshrined in this country's constitution. When Trinidad and Tobago acquired its statehood in 1962, Dr. Eric Williams, then Prime Minister, in his legendary first independence message, committed the new state to democratic governance. As he called on all citizens to dedicate themselves to all that was democracy, he posited, and I quote, "Democracy means equality of opportunity for all in education, in the public service, and in private employment." I repeat, and in private employment, end of quote. In keeping with this rousing charge of Dr. Eric Williams, the 1962 Constitution enshrined and protected certain human rights, integrating the philosophy of non-discrimination and inequality of treatment. But it did so only between the state and its citizens. It was not until 2001, when the Equal Opportunity Act became law, that discrimination and inequality of treatment between private institutions as opposed to public institutions and citizens were made unlawful. The Equal Opportunity Act equated protection against discrimination and victimization by virtue of race, sex, ethnicity, origin, religion, marital status, and disability in the public and private sectors, and it did so in education, employment, the provision of goods and services, and accommodation. The Equal Opportunity Act thereby finally ring-fenced the sphere of protection envisaged by Dr. Williams in his 1962 First Independence message. As the world's spotlight is refocused on discrimination and violation of human rights, the Equal Opportunity Tribunal, as the only specialized non-discrimination court in the English-speaking Caribbean, is striving enthusiastically amid the new national and international excitement to carry out its statutory mandate. The tribunal has responded to the urgent world challenge by increasing public awareness of the redress and the remedies the court provides, and enhancing the delivery of its services so that they are more user-friendly and accessible. I am so proud to report that the Equal Opportunity Tribunal is morphing into a contemporary human rights e-court outfitted with modern judicial tools and innovations. We have amended the Equal Opportunity Tribunal Rules 2016 and issued new practice directions to facilitate hearings by electronic means and e-filing of documents. The digitizing and restaffing of the registry have improved the capability of the tribunal to manage a more complex caseload. The tribunal, in partnership with iGovTT and assisted by the judiciary, launched its platforms for hearings by electronic means in July 2020. The first phase of the e-filing platform will be accessible in mid-October. The tribunal continues to partner with iGovTT for the completion of the final phase of its e-filing platform by January 2021. Optimistically, the tribunal, again partnering with iGovTT, has earmarked June 2021 to launch its own channel and full streaming of live hearings. In the interim, our website has been upgraded. All hearing fixtures and all of our written judgments are available on our website, www.eottt.org. We have recently opened our Facebook and our LinkedIn pages where our events are highlighted. For those persons who are not as tech-savvy, we continue to maintain a walk-in registry and in-person court hearings. We have identified a more accessible and appropriate space in Port of Spain, and we are working with the state to have the administrative matters completed sooner rather than later for this relocation. We have also started talks with some publishers, and resources permitting, we expect to publish our first official case reports in 2021. Our human resource team is evolving into a cadre of court administration specialists. We remain severely short-staffed as key positions are vacant. My thanks and appreciation to the members of staff to whom working from home is now real. Many have worked assiduously, Sundays and weekends included, as well as late into the evenings, to ensure that the tribunal continues to operate smoothly despite the setbacks of COVID-19. The efforts of the staff to safeguard our vulnerable infrastructure from exposure to COVID-19 is deserving of special commendation. To those persons, particularly at IGOV-TT and Industrial Court, you know who you are, who have been supporting the tribunal, we give a loud shout out. Thank you so much. Her Honor, Mrs. Lenore Harris, was appointed lay assessor in January 2020. I welcome her and thank her for her willingness to unreservedly contribute her wealth of knowledge as an accountant and auditor and former judge of the Industrial Court to the furtherance of the objectives of the tribunal. I am grateful for her support and tolerance. As part of our objective to develop external alliances, we have established a brain trust to examine the role and function of the tribunal and to suggest how the tribunal could optimize its functionality in this changing world landscape. We have invited eminent counsel, jurists, academics, and other stakeholders to contribute to our brain trust. The learning and guidance we gain from the brain trust is intended to inform the tribunal's first strategic development plan. We expect to be able to advance these initiatives in 2021. We look forward to furthering the alliances we have initiated with the Faculty of Law, University of the West Indies, the judiciary, including other superior courts of record, the CCJ, the Judicial Education Institute of Trinidad and Tobago, as we reach out to other institutes in the ensuing year. Non-discrimination and equality of opportunity and the protection of human rights are dynamic, sometimes passionate dogmas that underpin the democratic governance. We are encouraged by the statement of Her Excellency, Madam President Ms. Paula May Weeks, in her independence message, expressing her interest in non-discrimination. This has been bolstered by the recent assurance of the Right Honorable Prime Minister, Dr. Keith Rowley, to take another look at the legal framework for non-discrimination. The tribunal embraces the awareness and vision of Her Excellency and the Honorable Prime Minister. As we reflect on restructuring the law, a good consideration may be to provide complainants with the option of a direct route to the Equal Opportunity Tribunal while continuing to facilitate conciliation at the Equal Opportunity Commission for those who prefer that route. The present procedure that requires all complaints to be lodged at and investigated by the Equal Opportunity Commission before reaching to the tribunal could be time-consuming and self-defeating. It may be beneficial to rectify the system to allow complainants seeking urgent relief, such as injunctions, to approach the tribunal directly without having to forego time and opportunity at the Commission. The potential for protracted delays between the occurrence of the grievance and the resolution of it undermines public confidence in the system. Justice delayed may be justice denied. As the national community echoes global concerns about racial discrimination and injustices, we are jolted to look inwardly at the mechanisms that are available within this society to eradicate bias, discrimination, and prejudice. This country is fortunate to have first world legislative tools such as its Republican Constitution and the Equal Opportunity Act to shield its citizens. Aggrieved persons must be aware of their rights and make use of the law for protection fearlessly and confidently. The tribunal gives the assurance that it is striving tirelessly to provide the society with a forum where the individual can have their complaints of discrimination, victimization, and offensive behavior that are within the tribunal's remit expeditiously and judiciously adjudicated. 2020-2021 is a watershed year for the tribunal as it marks 1 decade since the tribunal received its first complaint. We are optimistic that, God willing and COVID permitting, we can celebrate that occasion with the merriment that it deserves. Thank you and be safe.